So, very good evening, friends. Today we have the privilege of having with us CA Sanjay Singhal who is an insolvency professional as well. And we have requested him to deliberate on the case laws which are covered in limited insolvency examination. So, with this, over to Sanjay Singhal Sanjay Singhal please. Sanjay Singhal you are not audible. आवाज नहीं आ रही है आपकी. नहीं सर, अभी भी नहीं.
अब आ रही है सर?
Yes, now it's okay.
1 second. आरके जी ऑडिबल है?
Yes. Now you are audible and visible. Yes.
ठीक है सर. सो थैंक्स आरके जी, आपने मुझे अपॉर्चुनिटी दी. जो भी मेरे पास लिटिल नॉलेज है उसको मैं सभी पार्टिसिपेंट के साथ शेयर करूंगा. उनकी भी नॉलेज से मेरी भी नॉलेज इंक्रीज होगी डेफिनेटली. और जितने भी केस लो हैं एक्चुअल में मैं आपको दिखा देता हूं. पहले देयर आर 27 केस लो इन सुप्रीम कोर्ट के जो हमारे सिलेबस का पार्ट है.
उसके साथ काइंडली इन इंग्लिश सर.
ओके. So there are 27 case law which are related to Supreme Court, which are part of our syllabus. Apart from these 9 High Court case laws and 17 case laws of NCLAT and 7 case law of NCLT. So 27 plus 9, 36 plus 17. सो हमें ये सब 60 केस लो करने हैं. सो हम उसमें देख सकते हैं वी कैन प्रायोरिटाइज सुप्रीम कोर्ट केस लो, हाई कोर्ट केस लो एंड एनक्लेट केस लो. These case laws are on different aspect. So what I have did, I have combined the case law on the same aspect. Like there are a sequence in the IBBI case laws. There are 1 to 27, but I have changed the sequence in my presentation. And depending upon the subject, like there are 3 case law which is pioneer urban land and land infrastructure, which is related to real estate. Then again the same case law of Chitra Sharma, which is the related to same aspect. And next is the Manish Kumar, so 17th number. So I have what we will do, we will discuss these 3 case laws in one sequence. Okay. So let's start from the first case law, Innovative Industries Limited versus ICICI Bank. Hope the slide is audible to everyone.
No.
Okay.
Not yet, sir.
Let me share the screen. Now it is
Yeah, yes, sir. Yes, sir.
okay. So this was the one of the first case law which was filed before the Supreme Court. Judgment was given by the Supreme Court was a landmark judgment. So many of the exam still the question is asked from this case law. This case law is Innovative Industries Limited versus ICICI Bank and others. So application was filed by the ICICI Bank Limited. ICICI Bank Limited, ICICI was the financial creditor of Innovative Industries Limited. So ICICI filed the application under Section 7 of the IBC. Basically, Innovative Industries Limited was a company which was based at Maharashtra. They did not pay. They made the default in ICICI Bank repayment of loan. So application was filed. What the stand that was taken by the Innovative Industries is that basically they have already filed the application under Maharashtra Relief Undertaking Act. Basically, it was a state government act to save the unemployment in the state of Maharashtra. Basically, if there was a sick unit or there is a unit or there is an industry or the company which was not able to pay its debt, the state government provide the protection under this act. They provide the relief or the moratorium for 1 year in the first instance for payment of debt, and it can go up to 15 years. That moratorium of not paying the debt can go up to 15 years from 1 year, then again it can be extended up to 15 years. And the state government can overtake that company as well if required, so that the employment can be saved in the state of the Maharashtra. So they take the basically stand that we have already registered we have filed the application under the Maharashtra State Government Act, and we are and our our data is not legally due in much as that notification of this Maharashtra Relief Undertaking Act and all the liabilities has been suspended for the first 1 year in the first instance and another period of 1 year under the second notification. So they are saying we are not liable to pay the debt of the ICICI Bank. So when the matter goes up to an NCLT, so NCLT and NCLAT, they did not accept the fact or the stand of the Innovation Industries Limited and admit the application of Section 7. When the matter again at the end goes to the Supreme Court, there was a two question. Whether one of the question is that there are two acts on the same aspect. So whether the appellant, whether the Maharashtra Relief Undertaking Act is repugnant to the IBC code, whether the appellant vested right under Maharashtra Act can be interfered with the IBC. So if the application is already registered under the state act, the application can be filed under the IBC code, which is a law enacted by the central government. And the one question is whether the application filed by the erstwhile director on the behalf of the company is maintainable once the IBC's insolvency resolution is appointed to manage the company. Basically, IRP, insolvency resolution professional, is appointed to manage the company. Basically, the appeal in the Supreme Court was filed by the director of the company on the behalf of the company. So since the application was already admitted and by the NCLT, so the director was not able to, or director was not authorized to file the appeal on the behalf of the company, as they have been already suspended when the application was admitted by the NCLT. So when these issues goes in front of the Supreme Court decided that we will admit the appeal, because the Supreme Court found substance in the appeal taken on the behalf of ICICI Bank that present appeal at the behest of erstwhile director of the appellant is not maintainable. Supreme Court, according to the Supreme Court, once the insolvency resolution professional is appointed to manage the company, the director who are no longer in the management obviously cannot maintain an appeal on the behalf of the company. Still they accept the appeal because they said that it is the first appeal under this act or this code which has come in front of us. So we will take it and deliver a detailed judgment so that all the court and the tribunal may take a notice of paradigm shift in the law. So on this basically player, they accept that appeal. So what is the decision of the Supreme Court? Supreme Court said that Supreme Court cleared that while hearing this aspect, or after Supreme Court cleared that the scheme of the code is to ensure that when a default takes place, in the sense that a debt becomes due and is not paid, when the default takes place, basically this is clarified by the Supreme Court, when there is a debt become due and is not paid. And again, what Supreme Court clarified that when it comes to a financial creditor triggering the process, Section 7 become relevant. Under Section 7, subsection 1, a default is respect of a financial debt owed by any financial creditor of the corporate debtor. Means that the application, when there is a default, there are two financial creditor. Default is made in respect of one financial creditor. The application can be filed by the other financial creditor as well under Section 7. And the main question is regarding to the repugnancy, which is the whether Maharashtra Relief Undertaking Act is repugnant to the IBC code. Repugnancy, Supreme Court in this act, in this case, clarify that what is the mean by the repugnancy. Repugnancy means when a situation in a situation where there is a two act for the same fact, where there are two enactment on the same fact and which are produce the different legal result. Like there are a same situation on there is a state code exist and the center code exist, and the both code are producing the different result. So there is a direct collision with each other, and which is reaching to a situation that it is impossible to obey one without disobeying the other. There is one employee and there are two bosses, and bosses are giving the instruction, and following the to follow the instruction of first boss, the employee has to disobey the instruction of the second boss. So it's like a situation, if I explain in simple word, is like a situation, it is like this type of situation. So here the doctrine of repugnancy, Article 254 of the Constitution came into the play, and which say that when there are two code of state and central government and they are repugnant to each other, then the act or the code of the central government will override the code of act of the state government. The Supreme Court held that for the reason stated below, the Maharashtra Act cannot stand in the way of the CIRP under the code. One, that is what Maharashtra Act is repugnant to the code. As the Maharashtra Act, the state government has the power to take over the management of the undertaking and impose moratorium in much the same manner as the contained in the code. Unless the Maharashtra Act is out of the way, the Parliamentary Act or the IBC code will not be hindered and obstructed in the same manner that it will not be possible to go ahead with the IBC outlined in the code. So Supreme Court said that unless the Maharashtra Act is out of the way, the IBC code, the provision of IBC code cannot be implemented in this case. So the doctrine of repugnancy came into the picture. And there was one more ground of the appellant that he has some vested right which could not be interfered by the code. So Supreme Court held that it is precisely for the reason that the non-obstant clause, Section 238, जो है non-obstant clause in the widest term possible is contained in Section 238 of the code, which came in which has the relevant provision that this IBC code will override the other act. For the reason stated, the Supreme Court was of view that tribunal was correct in appreciating that there would be repugnancy between the provision of two enactment. So I'm able to clear the fact of this case.
जी सर, अच्छा है, और अपनी सुविधा से आप स्पीड रखें तो कोई दिक्कत नहीं है सर।
Okay.
तो जल्दी हो रहा है, और कोई चीजें आप हिंदी में बताना चाहें तो हम लोग को तो ज्यादा आनंद आएगा, लेकिन इंग्लिश में उसको एक्सप्लेन करते ज्यादा बेटर है। कुछ लोग हैं जो इंग्लिश वो हिंदी का दिक्कत है।
Not an issue.
प्लीज।
So there are basically I have made 2 slides on this case to cover all the fact of the case, all the important fact of the case. If you go by the basically the fact of the case from the website, then it's a 10 to 15 page decision.
जी सर।
So section 238 is the important thing, and doctrine of repugnancy, article 254 of the constitution. These are the two important fact of the or the you can say key part of this case law. Next case is Mobilisation Innovation Private Limited versus Kirito Software. So let me explain you the background of this case. There was a show, Nach Baliye show, which was on the Star TV. So Star TV was organizing a show, Nach Baliye. So the Star TV has given the some basically like televoting and other software related services to it. It has hired the Mobilisation Innovation Private Limited. Mobilex Innovation Private Limited was hired by the Star TV to conduct the show, to provide the support related to the software, televoting and other related aspect. So Mobilex outsourced some part of his contract to the Kirito Software Private Limited. And what was it? It was to conduct the free telephone, basically toll free to online voting, toll free voting. But at that time there was a toll free number was given on the which viewer has to cast their vote. So that service was outsourced by the Mobilex Innovation to the Kirito Software. So from the basically this is a chart which I have made. On November 13, the work outsourced to Kirito Software, and from the November 13 billing was on monthly basis. So on monthly billing, the Kirito Software raised a bill to the Mobilex, and Mobilex pay the bill. So in December 14, what happened? Kirito Software and Mobilex signed a non-disclosure agreement, which was with effect from November 13. So with effect from November 13, in December 2014, they signed a non-disclosure agreement. And what was the clause of the non-disclosure agreement? That Kirito Software did not disclose anywhere that it has a agreement or a contract with the Mobilex Innovation related to the Nach Baliye show on Star TV. This was the one of the key clause of the non-disclosure agreement. So after signing the non-disclosure agreement, Mobilex came to the knowledge that Kirito Software has disclosed these information on his website. So in January 15, they withhold the payment, quoting the reason that NDA was breached. The non-disclosure breach of the non-disclosure agreement, NDA, they withhold the payment of Kirito Software. So in December 16, when the IBC came into the picture, Kirito Software issued a notice under Section 8 and filed an application under Section 9 of the code. A demand notice, if you see the point number 3, a demand notice dated 23rd December 2016, sent for a 20 lakh under Section 8 of the new IBC by an email dated 2016, and accordingly the appeal was filed. When the matter goes to the NCLT reject the application, saying that there is a dispute exist. When the appeal was email was done by the notice, demand notice was sent, the appellant responded to therefore said that nothing notice stating that there exists serious and bona fide dispute. When the notice was sent by the Kirito Software under Section 8, the Mobilex countered the notice that there is a dispute exist between the parties relating to the breach of the NDA. And when the matter goes to the NCLT reject the application of the Kirito software, saying that there is a dispute exists. But when the matter goes to the NCLT admit the application, saying that though there is a breach of non-disclosure agreement, but this does not amount to the dispute as defined in the IBC code. Accordingly, the Mobilex filed the appeal in the Supreme Court. So when the matter reached to the Supreme Court, what is the argument given by the respondent, means Kirito software, was that Section 5 subsection 6 cover only three things. Section 5 subsection 6 define the dispute, and it cover only three things, which is existence of amount of debt, quality of goods and service, and breach of a representation or a warranty. And since these three things does not cover the NDA, breach of NDA, so it would not come within the definition of dispute. This was the one basically argument made by the Kirito software. And another argument was the breach of NDA is a claim of unliquidated damage which has not been crystallized. So basically he's saying there is a breach of this NDA, so it is unliquidated, it has not been liquidated or has not been finalized, that how much loss has been made or occurred by the Mobilex due to the breach of NDA, and there is no legal proceeding has been filed, and Kirito Mobilex has not filed any case in any court or appellate tribunal against the Kirito. So there is and none have been titled so forth. Therefore, there is no real dispute on the fact of the present case. Basically, this point number 2 related to unliquidated damage and legal proceeding. This came in the section 8 subsection related to the section 8 subsection 2, जो हम अभी आगे देखेंगे, which we'll see in the next point. So the counter argument was on the behalf of appellant or the Mobilex is that if you ignore the first, which is some disparate aspect, we are directly going to the second argument that under section 8 subsection 2, the existence of a dispute, if any, and the record of pendency of the suit or the arbitration proceeding file must be read as existence of a dispute. Or basically, if we refer to the section 8 subsection 2, जो कि I have mentioned in this slide, section 8 insolvency resolution by the operational creditor, subsection 2, the corporate debtor shall within a period of 10 days of receipt of demand notice or the copy of the invoice mentioned in subsection 1 bring to the notice of the operational creditor existence of a dispute. Now there is written if any, or earlier it was not there. When the code was initially passed by the parliament, it was written that existence of dispute if any and record of the pendency. Like when you see that this first reference substituted by the IBC second amendment 2018 with effect from 6th of June 2018 for the word if any and. So if any and was replaced by the if any or. But when this case was in the Supreme Court, there was a language that if any and. So this was changed by the second amendment in 2018. So existence of dispute if any and record of pendency. So Kirito software took a stand that since there is a dispute, the section 8 subsection 2 clearly say that existence of dispute along with the record of pendency of suit or arbitration proceeding. So there can be a dispute, but there is no legal proceeding. So it did not come in the did not cover in the section 8 subsection 2. So they took a stand. So the counter argument was that section 8 subsection 2, the expression must be read as and can be read as or. And the second, what he said that what the stand was taken by the Kirito software that there are three parts of the section 5 subsection 6 is amount of debt, quality of goods or service, and the breach of representation warranty. So definition of dispute under section 5 subsection 6 of the code is inclusive one. So what is the counter argument of the Mobilex innovation? The definition of dispute is inclusive one. So what is the definition of dispute? The definition of dispute is section 5 subsection 6 is dispute includes a suit or arbitration proceeding relating to these three parts. So they say that this definition is inclusive one. And what is the basically stand of the Kirito software is that this three part does not cover the breach of the non-disclosure agreement. They only cover the breach of representation or warranty. So now the issue before the Supreme Court is the existence of dispute and the word and or which we have already discussed. And there are other aspects which has been other argument or the play which has been taken during the course of proceeding. So one is that the test of there was a Supreme Court decision in Madhusudan Gordhandas versus Madhusudan, in which Supreme Court has held that inability to pay debt is cannot be a ground for winding up of a company. So there was a earlier Supreme Court decision in Madhusudan Gordhandas that if the company is not able to pay the debts, that cannot be a ground to for the winding up of the company. So they quoted this case as well. So one by one we will see that in these 6 issues what Supreme Court has decided. One Supreme Court first observation was Supreme Court that there should be a dispute which is pre-existing. It means that dispute has to be pre-existing before the when the application of section 9 is made. Dispute has to be, or when the notice of the section 8 is made, dispute has to be existed before that. Note that when it is not issued, it should not be like that. Then a notice under section 8 is served to the CD and CD raised some issue or some dispute. And second is word and or. So Supreme Court upheld that the word and has to be read as or, keeping in the mind that legislative intent and fact that an anomalous situation would arise if it is not read as or. Otherwise, what will happen that when the case is filed, when the dispute has to be go to the legal proceeding first, then application can be filed under section 8 or 9. Because it is if we read and as and not or, then this would anomalous situation would arise. So this was the observation of the Supreme Court. So Supreme Court further observed next part, Madhusudan Gordhandas. Supreme Court basically we can say that Supreme Court dismissed this decision. That Supreme Court further observed that since inability to pay debt is no longer a ground for winding up of a company, the principle inadequate in landmark judgment of Madhusudan Gordhan has disappeared. With the disappearance of the grounding section 217 of Companies Act 20, it does not hold good under the present regime of the code. So Supreme Court said that now this decision does not hold good in the present regime of the code. One of the ground was taken that A cannot go into that detail. Can A go into the detail that dispute exists or does not exist? So Supreme Court held that A has to see at this stage whether there is a plausible contention which require further investigation and the dispute is not a patently feasible legal argument or an assertion of the fact unsupported by evidence. So Supreme Court held that A has to see कि जो dispute raise किया गया, the dispute which has been raised is supported by the evidence and it is a legal argument and dispute genuinely exist. So A has to ensure that. And Supreme Court held that the dispute is the definition of section 5 subsection 6 is the inclusive definition. And Supreme Court also admitted that we have seen that a dispute is said to exist so long as there is a real dispute as to payment between the parties that would fall within the inclusive definition contained in section 5 subsection 6. The correspondence between the parties would show that on the 30th January 2015, the appellant clearly informed to the respondent that they have displayed the appellant confidential client information and client campaign information on the public platform, which constitute a breach of trust and a breach of NDA between the parties. So Supreme Court also held that this come into the definition of the dispute, inclusive definition of the dispute. So the Supreme Court dismissed the appeal and set aside the judgment of appellate tribunal. So it upheld the judgment of NCLT and set aside the judgment of unclate. And the appeal was not appeal of the, we can say, application of the Kirito software was not admitted as there was a dispute. So what is the crux of the case? The crux of the case is the Section 5, subsection 6, the definition of the dispute, which has been more clarified by the Supreme Court, that it is an inclusive definition. And second is the existence of dispute. Basically, at that time, there was a word. If you see the Section 8, subsection 2, there was a word, existence of dispute, if any, and record of pendency. So Supreme Court clarified that this end can be read as or. Please allow me 2 seconds. I have to attend someone. 1 minute. Please allow me. This next case is K. Kishan versus Vijay Nirman Company Limited. Basically, this is not in the sequence of the case law, but I have, you can say, because these two case law are related to the same aspect, related to the dispute, existence of the dispute. The third case law is in our syllabus is the Rani Sugar and Chemical Limited. This is the K. Kishan is there in the on the in the 15th case law, but I have changed the sequence because these Mobilex and K. Kishan are on the same aspect. So what is the background of the K. Kishan versus Vijay Nirman is? My screen is visible to all?
Yes, sir. Yes, visible, sir.
Okay. Okay, fine. So in the present case, there is a company called Vijay Nirman Private Limited, VNCL. VNCL has intended to a subcontract with KCPL for the construction and widening of a 2-lane highway to 4-lane highway. So they have given us, VNCL was having a contract from the government. A part of the contract was given to KCPL, Khurshedabad Construction Private Limited, was subcontracted to the KCPL for that road construction work. Apart from this, they have some other business relation. So there was a tripartite agreement. There was one other company called SDM PPL, SDM Public, like the SDM PPL is the short name of that company. So they have a tripartite agreement between the KCPL, VNCL and SDM PPL. So there was some other business relation was also there. So during the course of the project, the dispute arose between the VNCL and KCPL, and that was referred to the arbitral tribunal. So the decision came when the decision came from the arbitral tribunal was in favor of the VNCL. The said award was in favor of the VNCL for a sum of rupees 1.72 crore. And there was another claim related to that project was allowed in favor of the Vijay KCPL, that was related to rupees 13.7.5 crore. So after the arbitration dispute decision, so notice sent by the VNCL to the KCPL to pay a sum of 1.79 crore under Section 8 of the IBC. So VNCL asked for the payment. KCPL say कि there was another dispute. There is another decision of related which has a higher award. So they did not pay to the VNCL. So VNCL sent a notice under section 8 of IBC to the KCPL. Within 10 days, KCPL disputed the invoice that was referred to the notice, stating that the said amount was in fact subject matter of the arbitration proceeding, and as per the KCL books, VNCL is liable to pay a larger amount to them. So they did not pay the amount, and they disputed the amount. And after the notice that is under section 8, they file appeal under section 34 of the Arbitration Act, under the Arbitration and Conciliation Act, to challenge the decision of the arbitration tribunal. So they filed appeal under section 34. That appeal was also within the timeline. The petition was filed within the timeline set under the section 34 of the Act. So when that matter goes to the NCLT, so NCLT was viewed that section 34 petition was pending, was irrelevant for the reason that claims stood admitted. So basically NCLT admit the application, stating that since the KCPL has not basically disputed the claim, basically they have admitted the claim, but said that there is a higher amount is pending. So on that ground, NCLT admitted the claim, and there was no stay of award. So therefore the section 9 application was admitted by the NCLT. So on the when the matter goes to the appellate tribunal, that was met with the same fate, and the application, the decision of the NCLT was upheld. When the matter goes to the Supreme Court, so basically Supreme Court held that insofar as the operational debt is concerned, all that has to be seen as whether the said debt can be said to be disputed. And we have no doubt in stating that the filing of section 34 petition against the arbitral award shows that there is a pre-existing dispute, which culminates at the first stage of the proceeding in an award, continue even after the award, at least till the final adjudicatory proceeding under section 34 and 37 has taken place. So Supreme Court said that there is a pre-existing dispute because there was a decision or arbitral tribunal, but same has been challenged under the act, under the said act, and that appeal or that challenge is still under process. So there is a dispute which has been not taken care or the not considered by the NCLT and NCLAT. And Supreme Court also said that operational creditor cannot use the IBC either prematurely. So Supreme Court said that this application is premature because the final award has not been come, or because the KCPL has challenged the decision. So this application is premature, or the Supreme Court clearly said that operational creditor cannot use the IBC either prematurely or for extraneous consideration or as a substitute of debt enforcement procedure. So you cannot say that if you do not pay our debt, then we will go to the IBC. So you are using that IBC as a substitute for the debt enforcement procedure. So Supreme Court said that section 238 will also not applicable. Section 238 contains the non-obstant clause would not apply in this case, as in the present case court held that there is a no inconsistency. On the contrary, award passed under Arbitration Act together with the step taken for its challenge would only make it clear that operation related happened to be a disputed one. So वो जो award और जो proceeding चल रही है, it has cleared that there is a dispute and said there is no inconsistency. So for all the above reasons, the Supreme Court was the view that judgment of NCLAT need to be set aside and therefore reversed. And so Supreme Court reversed the NCLAT and NCLT judgment. So these two cases related to the dispute. So what is the crux of the case is that if there is a dispute existed, it came in the definition of inclusive definition of the dispute under section 5 subsection 6. The appeal application under section 7 or 9 cannot be admitted. Next case is Dharani Sugar and Chemical Limited versus Union of India. Basically on 12th of February to after when the IBC was approved by the passed by the parliament, after that RBI issued a circular on 12th of February 2018, and under that circular the RBI instructed all the banks that where there is a default of 2000 crore, more than 2000 or more than 2000 crore by any company in any industry, then and within 195 days, and there are one or the and that so there if there is a default of 2000 crore and the exposure of over 2000 crore is fully implemented before 190 days from the enact date of the first default, the lender will have to file a application as financial creditor under the insolvency code, so that if there is a default and the default is not cured, then there is a default of 2000 crore, exposure of 2000 crore, then the lender has to file application under section 7 of the IBC. So it is to be noticed that the source of power of issuance of aforesaid circular, the circular की power कहाँ से ली उसने RBI ने, the source of power was the section 35A of the Banking Regulation Act, read with the central government circular dated 5th of May 2017, section 35A and section 35B of the Banking Regulation Act. That was the source of the power of by the RBI. So what circular was saying that for all the industry, there was no differentiation between the industries. So what is the ground of the appeal? This issue was challenged in the Supreme Court. So what is the ground of the appeal? To apply a 180 days limit to all the sector of the economy without going into the special problem faced by each sector would treat unequal equal and would be arbitrary or discriminatory and therefore violate the Article 14 of the Constitution of India. So this was the ground. Basically, they saying that there are a number of sector in the industry. The RBI issued a circular that if there is a exposure of 2000 crore or more, and that was not, and there is a default and that has not been cured within the 180 days time limit, so they can file they has to file application under section 7. So it is a basically we can say it's a arbitrary circular because there can be one second. So this was the ground कि जो circular है, it is a arbitrary one because there is no intelligible differentiation between the industry. Order completion router किया है. So what sorry for the disturbance, and what is the issue involved? Whether section 35A and 35B AB and introduced pursuant to the ordinance and the amendment are unconstitutional, and whether the impugned circular dated which was issued by the RBI is ultra vires to the Constitution. So after hearing all the grounds by the appellant and counter argument by the respondent, so what is the decision of the Supreme Court is Apex Court clear that these provisions which give power to the RBI certain regulatory power cannot be said to be manifestly arbitrary, and hence the court categorically held that the plea of the constitutional validity fails. So further, Supreme Court held that the impugned circular to be ultra virus, as the whole declared to be no effect in law. So Supreme Court held that the circular will be ultra virus. These provision under the Banking Regulation Act, which gives the power to the RBI, is valid, but the circular is ultra virus. Consequently, all action taken under this circular must fall along with the said circular. So if any bank has taken any action or filed any application, that will not be effective, that will fall, that application will fall. So this was the basically these are the fact of the case. So there was a circular issued, circular was challenged under Article 14 because the circular treated all the industry, all the unequal equal. So that was challenged, and the power of the RBI was also challenged, the section 35A and 35AB. So next three case will be the very important case. Two cases related to the Supreme. These three cases are related to the real estate industry. Two are from the Supreme Court, and one is from the these three are related to the decision of the Supreme Court only. So one is Pioneer Urban and Land Infrastructure versus Union of India. The first case is so basically when the IBC was passed by the Supreme Court, in those days there was the basically real estate sector was going through the many problems. So basically what is the basically we can say matter of the real estate project. Real estate builder has taken the money from the banks, they have taken the money from the home buyer as well, and they have not developed the project, and they run away. So but what is the definition of the financial creditor does not include the home buyer. Definition of the operational creditor also does not include the home buyer. So pursuant to the IBC code, a lot of the real estate projector have been included within the so there was a basically you can say ordinance was passed by the central government, which says that the home buyer will be the financial creditor under the code, and they could initiate the insolvency proceeding against the real estate developers. So this was the basically ordinance was passed by the central government, which was approved, we can say approved by the parliament in the next session. So when the ordinance was passed, this appeal was the ordinance was challenged in the Supreme Court. So initially before the ordinance, there was a Supreme Court judgment. Initially before the amendment in section 5 subsection 8, there was a lot were not considered as financial creditor unless they had a assured return or a committed return clause in their agreement, as held by the enclave on 21st July 2017. Basically, earlier the home buyer was not the financial creditor. So enclave in a one decision said that if there is an assured return or a committed return clause in the agreement between the home buyer and the developer or the builder, then those home buyer will be considered as a financial creditor because they have a assured return clause, which will fulfill the criteria of the debt or the financial debt. So it made a division between the home buyer because a certain category or a certain percentage of the home buyer is the financial creditor, and rest who are not covered who does not have the assured return or a committed return clause are not considered as a financial creditor. So this amendment which has made in the act was challenged by the real estate developer in the Pioneer Urban and Land and Infrastructure case on the following ground. What was the ground? One, that that the amendment is discriminatory in as much it treats unequal equal and equal unequal having no intelligible differencia. The second main ground was very valid ground. A good management which has several projects on its hand can be removed at the instance of one LOT or the one home buyer and either replaced. So the ground was that, like, there is a project, there is a builder who has this two or more than one project in hand. If there is a delay in one project or there is a default in one project, then that management and the rest of the project are going very good, then that management can be replaced on the application of one LOT or can be removed, and even the company can go into the liquidation, which is a commercial death to the company. And they also said that the amendment is made in spite of the fact that there is other regulation is also available, other option is also available, like RERA, or that you can say consumer forum is also there. So namely RERA, which deals in the real estate sector issue and provide for adjudication of dispute between the LOT and the developer. So they took a stand, real estate developer took a stand that RERA is also available to the home buyer. So after hearing the both the counter and the argument and counter argument, Supreme Court observed that from the introduction of explanation to section 5 of the code, it is clear that Parliament was aware of RERA and applied some of its definition provisions so that they could apply when the code is to be interpreted. The fact that RERA is in addition to and not the derogation of the provision of any other law for the time being forced also makes it clear that remedies under RERA to the LOT were intended to be additional one and not exclusive remedies. So Supreme Court clear that the RERA की जो remedy है, the remedy under the RERA provision are the additional remedy apart from IBC to the home buyer and not only the exclusive remedy. Court also held that even a process of harmonious construction, RERA and the code, if there is a basically if there is a we can say clash between the provision of the and the provision of RERA and the code must be held to be coexist, and in the event a clash, RERA must give way to the code. So Supreme Court clear that if there is a clash, first we will try that the provision of the both the code, RERA and the code, should be coexist, and if they cannot be interpreted in such a way, then the RERA must give way to the code. And Apex Court upheld the amendment made by the central government. जी, yeah.
संजय जी, मैं ये कह रहा था कि फर्स्ट ऑफ ऑल वी शुड टेक द न्यू केस लॉज, इसमें भी सुप्रीम कोर्ट में भी
अच्छा
है ना, बहुत सारे केस लॉज है ना,
हाँ,
तो
हाँ,
लेट अस टेक द केस लॉज व्हिच हैव बीन इंट्रोड्यूस्ड न्यूली फॉर द फर्स्ट टाइम.
ठीक
बाकी
है.
इट इज एज पर योर कन्वीनियंस, जैसा आपको ठीक लगे. You are
मैं
going
क्या
to
करता हूँ
discuss
सर,
because you are going to discuss anyway all the cases.
तो
Maybe
कंटिन्यू इसी तरह से कर लेते हैं क्योंकि
okay, okay
हाँ,
sir,
हाँ,
okay.
थोड़ा सा
Okay,
मैं
sir.
ऐसा करता हूँ कि और ब्रीफ में कर देता हूँ.
No, take your own time, no issues.
Okay,
We can have another class, we can have 2-3 sessions more, no issues.
okay.
Hmm.
So next case is Chitra Sharma versus Union of India. In this case, this case is related to the several, you can say, writ petition filed by in the Supreme Court by the home buyers. So they clubbed those petition in this case and give the judgment. In this case, the IDBI Bank was involved. IDBI was the financial creditor of JP Infratech Limited, JIL. So when there was a default was made by the JIL, they filed the appeal under section 7. And appeal was admitted, IRP was appointed. So what is the main grievance of this case? The main grievance for filing the instant petition was, this petition was filed by the home buyer of the JP Infratech Limited, JIL, that the CIRP ignored the interest of the vital stakeholder in building the project, majority among them who are individuals who have invested their wealth hard-earned wealth in pursuit of having a human desire of having a own home, or having a home, or to have a home. So they said what is the grievance is that the individual or the home buyer who have given their wealth to the builder or to the developer, they are also, so they are not part of the financial creditor, they are not part of the you can say operational creditor. So they have been ignored in the IBC. Basically, this case related to the period when this amendment was not came into the picture. The amendment was not made by the central government. So this case was started before that. So before the amendment, what was happened when the case was filed on 16th of August 2017? I am showing a picture. So the case was started, CIRP was started on 9th of August 2017. You please refer this chart. CIRP started on 18th of August 2017. The IBBI made a press release, say that home buyer can fill Form F. Basically, these are the form. Form C is for the financial creditor. Form B is for operational creditor. Form C is for financial creditor. Workmen and employees for Form E. And there is another Form F for other creditor. So there was no clarity that home buyer, which form has to fill by the home buyer. So IBBI made a press release that home buyer can fill the Form F for their claim. When the matter goes to the Supreme Court here the petition of the argument of the home buyer, and Supreme Court in this case, what Supreme Court did that to facilitate the view of the home buyer being placed before the COC, the Supreme Court nominated a senior counsel practicing before this court to participate in the meeting of the COC under the code, under the section 21 of the code. So Supreme Court nominated one senior counsel, one practicing advocate as a authorized representative of the home buyer in the COC. So 18th August ko the Form F was made by the IBBI. On 6th of February 2018, 180 days completed. On 12th of May 2018, extended period 270 days completed. And the matter was until the 270 days completed, and the matter was there was no resolution applicant. On 6th of June 2018, so ordinance was introduced by the central government, and home buyer was declared as financial creditor. So matter was till the time matter was going in the Supreme Court. So now the complex situation has arisen. There was home buyer in the JIL cases who has made a petition to the Supreme Court that their interest has to be taken care. Supreme Court has appointed a senior counsel as their representative. They said that though the senior counsel has been appointed, but he has no say in the decision making of IBC, COC. So because he does not have any statutory voting right. And now since the decision has not been finalized by the Supreme Court, now the ordinance has been introduced by the central government, and the home buyer was made the financial creditor. So what Supreme Court did? Supreme Court said that a workable arrangement was to be put into the place by appointing. This is not. So in the present case, point number 5, peculiar situation has arisen as a result of which the status of the home buyer, which had not been recognized prior to 6th of June, has now been expressly recognized as a result of the amending ordinance. Having regard to the material change which has been brought about the amendment of the code by the ordinance, and the fact that this court has insisted the proceeding to ensure that the home buyer are protected, the court was of the view that it is appropriate and to do the complete justice to secure the interest of all the concerned, the CIRP should be revived and COC reconstituted as per the amendment provision to include the home buyer. So now Supreme Court want to do the justice and want to set a, you can say, want to give a landmark decision. So Supreme Court took a call ki, what we will do, since now the situation is that matter was going to the Supreme Court, in under process in the Supreme Court. Earlier, when the appeal was filed, home buyer was not the financial creditor. During the course of the case in front of Supreme Court, the home buyer was declared as financial creditor. So Supreme Court has a power under Article 142. It is called as Brahmastra. So what they took a call that we will do the complete justice with the home buyer. We will revive the 180 days limit, the CIRP. We will again start the CIRP, and the home buyer will be part of the COC as per the amendment or the ordinance. So using that Brahmastra or Article 142. So what they did, they revive the CIRP. Then they said that the new COC will be reconstituted as per the amended provision to include the home buyer. We read the point 5. The court was viewed that to appropriate and to the complete justice and to secure the interest of the all concerned, the CIRP should be revived and the COC reconstituted as per the amended provision of to include the home buyer. So power under Article 142 would be warranted to render the complete justice. So basically, we can say that this is a very famous case. Chitra Sharma case was very famous case. It was discussed in all the media, covered by the media as well. So Supreme Court, basically, you can say Supreme Court overrule everything just to do the justice with the home buyer, using the power of the Article 142. So Article 142 give the has given the very wide power to the Supreme Court. So they can overrule or they can revive the any timeline. So a new COC was reconstituted and the home buyer was the part of that. So any issue in this case? Anyone? Am I able to explain? सभी लोग हैं?
हाँ जी सर.
Excellent, sir. You can go ahead, sir. You can go ahead, sir. Excellent.
Okay.
Please continue, sir. Please continue.
Because
Excellent.
there is a long silence was there. Silence was there.
Excellent.
No, because everybody is put in silent mode,
Muted.
so that
Okay.
there is no disturbance. Because
Yes, sir.
everybody is listening. Yes, please.
Yes,
We are
sir.
listening. We are listening, sir. No problem.
Okay.
Yes, sir.
Good-
Because we are
good session,
muted,
good
sir,
session.
without disturbance.
You are going well.
Thank you, sir. Thank you. So next case is Manish Kumar versus Union of India. So Union of India is the respondent, means there is a decision of a central government or any body of the central government has been challenged in the case. So before going to the this case, we have to just revise that pioneer urban land. So in the pioneer case, what was the challenge? Because the government has said that the home buyer will be the financial creditor. So there was one argument was also made that a good management which has several projects on its hand can be removed at the instance of one LOT. So even Supreme Court did not, at that time, Supreme Court even did not take into consideration that argument and upheld this amendment. Now this argument produce the result. And even the one LOT has filed even the single LOT has started filing the application under Section 7 of the IBC against the developer. So government took into that, considered that those challenges also, and they made an amendment again to the Section 7 subsection 1. So one proviso was incorporated in Section 7 subsection 1, which said that the allotee under a real estate project or the financial creditor desirous of triggering the IBC under the code, insolvency under the code, are required to file an application jointly by not less than 100 of such allotee under the same real estate project. or not less than 10% of the total number of LOT under the same real estate project, whichever is less. So now the government, अब वो क्या हुआ, what happened कि government परेशान हो गई. When they made the amendment, first they did not cover the home buyer. So the home buyer परेशान थे कि why we are not the part, we have given the money to the builder and we are not the financial creditor. When they made the financial creditor, now the what happened, they filed the application. Even one home buyer filed the application. Now the builder lobby थी that came into the picture. They represent before the government कि देखिए कोई भी anybody can file the application. So government made the amendment. They said that like there is a one project under which there is a 1,000 in one project. So we took an example. We took a 3 scenario. So in the one project of real estate project, there is a 100, we can say flat is there. So application can be filed by 100, minimum 100 or 10% of the total number of LOT. So if there is a 800 LOT, then 10% of that is 80 and minimum is 100, whichever is less. So minimum 80, if there are 800 allotment is there, LOT is there, then minimum 80 LOT can file the application under section 7. Or in another scenario, there is, we can say there is a real estate project which has the 1200 LOT or 1200 flat under construction. So minimum 100 or 10% is 120. So whichever is less. So 100. So in that case, 100 LOT can file the section 7 application. So this was the amendment. Proviso was incorporated. Apart from this, they have made that there has to be same project. Like a builder has 3 projects. One is Gurgaon, another is in Chennai. So the application has to be filed by the LOT of the Gurgaon project only. If there is or another project are going in Chennai, in Noida, so the project of LOT of those projects cannot be a part of the application. For the same real estate project, the application has to be filed. Further, they made another proviso that if there are any cases still application is already filed before this amendment, those applications which are under process in NCLT has to be withdrawn, and they have given a time of 30 days that they have to, you can say they have to get the approval of that 100 LOTs in that application. Like Mr. X has filed application under section 7 in NCLT before this amendment. Now the amendment came into the picture. So Mr. X has to arrange the 99 more LOT of the same project so that application can be heard by the NCLT. So further, the petitioner sought to challenge another proviso that those applications under section 7 which has not been admitted or means that which are under process with NCLT would stand withdrawn within 30 days. वो withdraw हो जाएंगी अगर within 30 days if newly declared minimum threshold of 100 LOT or 10%, whichever is lower, was not garnered by the respective applicant. So applicant has to arrange that has to ensure the minimum threshold so that his application can be heard by the NCLT. Otherwise, if he did not ensure the minimum threshold of within 30 days, then his application will be withdrawn. So when the appeal was filed before the Supreme Court by the Mr. Manish Kumar, the petitioner has approached the Supreme Court under Article 32 of the Constitution of India. The petitioner contended that the proviso in Section 7 subsection was unreasonable, arbitrary, irrational, ultra vires of the Constitution and violated basic fundamental right. He said that a fundamental right of the individual has been violated because if there is the individual was not able to file the appeal under Section 7, so his fundamental right was violated. It was contended that amendment result in hostile discrimination between the petitioner and other financial creditor lacking any intelligible differentia. So, however, the Supreme Court has not accepted his argument. Supreme Court what way may be viewed as below to the LOT of real estate project has upheld the provision of amending the section 7 subsection 1 of the code. So Supreme Court upheld the provision, you can say amendment of the in the provision, and Supreme Court also further clarify that, for example, we have to now arrange a minimum 10% or at the 100 LOT. So if one person has more than one allotment, then what will happen? Then he will consider, like Mr. X has booked the 3 flat in a same project. So he will be considered as 1 LOT, not the 3 LOT. And in another scenario, Mr. X has booked the 3 flat, one in his name, one in his wife's name, and one is in father name. So those 3 will be considered as 3 LOT. In the name of his family, all independent allotment would qualify as separate LOT. And if there is a joint allotment of more than one person, like there is a flat which has been booked by Mr. X and Mr. Y, so that those are the joint LOT, so they will consider as one person, not the 2 LOT, because there will be the catch na, they have to arrange the 100 LOT or the 10% of the project. So you have to clarify how the 100 will count it. So Supreme Court has also clarified this as well. So these are the basically related to one aspect, the home buyer. 3 case, Pioneer, Manish Kumar are the same case. There was one case when they made in Pioneer, it was challenged by the builder or the developer, ki aapne, why you made the amendment and you consider home buyer as a financial creditor. Even they have given the one solid ground that one home buyer can challenge the one home buyer can challenge the good management, and good management can be replaced with the instance of one LOT. So even in that time, Supreme Court even upheld that, did not consider that argument and upheld the amendment. And now in this case of Manish Kumar, Supreme Court did the reverse judgment. And in Chitra Sharma, Supreme Court totally take care of the home buyer and use the Brahmastra, Article 142. Now there are next 3 cases. These 3 cases are ArcelorMittal, COC of SR Steel. These are the same company, corporate debtor, ArcelorMittal versus Satish Kumar Gupta, COC of SR Steel versus Satish Kumar Gupta. And next is the Swiss Ribbon. So these 3 cases are also very important. Basically, they have in these 3 cases, Supreme Court has clarified everything. In these 3 cases, everything, many aspects of the IBC code has been challenged by the appellant, and Supreme Court clarified a lot in these 3 cases. One is ArcelorMittal, India Private Limited versus Satish Kumar Gupta. So who was the corporate debtor in this case? SR Steel was the corporate debtor. So SR Steel was a very big joint corporate in the steel industry. So in the he did a default and his appeal was admitted. And Mr. Satish Kumar Gupta has been appointed by the NCLT as a resolution professional of SR Steel. So SR Steel, you can say, was a very big company. So usko jo resolution applicant the, that can also has to be a very big company. So there was 2 resolution applicant. One was ArcelorMittal India Private Limited, and second was Numitel India Private Limited. The case was filed by ArcelorMittal. There were 2 resolution applicant. One is ArcelorMittal and second is Numitel. When Numitel and ArcelorMittal filed their, you can say, their resolution plan, then Mr. Satish Kumar Gupta, who was the resolution professional, did not accept their resolution plan. At that time, the section 29 was recently inserted in the IBC. Basically, section 29A was not the not part of the original code, original draft or the original code, which was passed by the parliament in October 2016. It was later introduced by the central government with effect from 23rd November 2017. सो एनसीएलटी ने जो है अगस्त 2017 में उसकी अपील जो है सेक्शन 7 की जो एप्लीकेशन वाज एडमिटेड बाय द एनसीएलटी. Resolution professional was appointed. When the resolution plan was submitted by the resolution professional, so he said that the AMIPL, ArcelorMittal and Numital are not eligible under section 29A. So why he declared them ineligible under section 29A? So his logic was, or his reasoning was, resolution professional found that point number 5, ArcelorMittal India Private Limited, AMIPL, there was one company, AM Netherlands BV, was declared as connected person in the AMIPL resolution plan. So they AMIPL declared in the resolution plan that AM Netherlands BV is their connected party. So AM Netherlands BV was acquired by 29% equity in Uttam Galava. So AM Netherlands BV was having the 29.05% equity in Uttam Galava and also entered into a co-promoter agreement with the promoter of Uttam Galava. And Uttam Galava account was classified as NPA by the Canara Bank and PNB. So Satish Kumar Gupta said that so AMIPL is ineligible to submit the resolution plan. In second case, Numital case. Numital was a new company incorporated 7 days before the submission of EOI. So and Uttam Galava Numital was incorporated before 7 days before the EOI, and who was the promoter of the Uttam Galava? There are 2 or 3 companies on the financial of the based on the financial or the strength of those companies. Numital was eligible, or the Numital has applied because Numital was a new company. So on the strength of its promoter company, Numital has applied or submitted the resolution plan. So one of the promoter company of Numital was having one NPA account. So that was also been declared as NPA, ineligible by the resolution professional. When the matter goes to the NCLT, so now there was 2 questions. There was 2 key questions in this case was, one is the authority of the resolution professional. Can he say that the resolution applicant is not authorized to submit the resolution plan? Second is basically they said that we can pay the dues of the our NPA. They said that we want to buy the SR steel. So what we can do, we can pay our debt, and we can pay our debt. So the issue is arise ki what is the date when they can be considered as ineligible. So NCLT said that 6 point May, 3rd line, NCLT also held that date on which a person stand disqualified would be the date of commencement of the CIRP of the corporate debtor. In the SR steel case, it is 2nd of August 2017. Then it remanded the matter to the COC. So NCLT said that the date on which the person will stand disqualified or the scene will be considered as eligible or ineligible is the date of incorporation of commencement of CIRP. So this was the, so now they did not have any option, because now they cannot correct the NPA default. So they have submitted that we can pay the due amount of the banks, and so their stand. So now the matter was referred to the Supreme Court after NCLT and NCLAT. So key issue was the stage at which the eligibility of resolution applicant has to be seen and the power of RP towards resolution plan. So these are the two key issues which has been decided in this case. So the first this was argued at which parties were at loggerhead was the time at which subclause C can be said to be operate. According to Sri Mukul Rohtgi, who was the basically representing the Mr. Satish Kumar Gupta, in the original subclause C, pre-amendment time must necessarily be date of CIRP as mentioned by the section itself. So as section itself is saying, it was the argument of the respondent Satish Kumar Gupta कि वो CIRP की डेट होगी. According to Mr. Salven Singhvi, who was representing the ArcelorMittal, it is clear that since submission of a resolution plan is spoken of, it is time of submission of such plan and not any anterior stage. So the counter argument was कि the opening the section 29 subsection, sorry, section 29 capital A is saying the submission of resolution plan. So section itself say कि it's the time of submission of resolution plan has to date of submission of resolution plan on which it has to be considered that the resolution applicant is eligible or not. So the Supreme Court held that the opening word of section 29A furnish a clue as to the time at which subclause C is to be operate. The opening word of the section 29 state that a person shall not be eligible to submit a resolution plan. So Supreme Court said that Supreme Court took a clue from this line. A person shall not be eligible to submit a resolution plan. So it is clear, therefore, that the stage of ineligibility attaches when the resolution plan is submitted by the resolution applicant. So accordingly, the contrary view expressed by Sri Rohtgi is obviously incorrect, as the date of commencement of the CIRP is only relevant for the purpose of calculating whether 1 year has been left from the date of classification of a person as NPA. So Supreme Court clarified that the date is the date of submission of resolution plan when the ineligibility has to be checked. Further, Supreme Court held that a resolution applicant has no vested right that his resolution plan is to be considered. It is clear that no challenge can be preferred to AA at CIRP stage. So Supreme Court said that resolution applicant कोई ऐसा ये नहीं cannot take a stand कि उसका plan has to consider किया जाना चाहिए. It is a decision or the authority of the COC only. And in regard to the power of RP, authority of the resolution professional, the RP, Supreme Court clarified that the RP is not required. Point number 4, the RP is not required to take any decision. Point number 4 पे हम, the RP is not required to take any decision, but merely to ensure that resolution plans submitted are complete in all respect before they are placed before COC, who may or may not approve it. Section 32 subsection 2 clause G does not empower the RP to decide whether the RP does or does not contravene resolution plan does not contravene the provision of law. So Supreme Court said that RP has to submit all the plan to the COC and COC will decide that on the plan. So now Supreme Court has now the issue has gone to the Supreme Court. So Supreme Court, what Supreme Court did, so again in this case as well, Supreme Court used the power of Article 142 and give the additional time of 15 days to the both the parties, ArcelorMittal and the Numittal, to pay their dues. In order to do the complete justice, Supreme Court under Article 142 of the Constitution of India, and also for the reason that the law on Section 29 has been laid down for the first time by this judgment. So say कि Section 29 A insert होने के बाद first time कोई case हमारे पास आया है. So we are giving one more opportunity to both the resolution applicant to pay their NPA of their related corporate debtor within a period of 2 weeks from the date of receipt of this judgment, and accordance with the proviso to Section 29A. So if they pay their debt within the aforesaid time period, both resolution applicant can resubmit their resolution plan. So Basically NCLT ने has cleared that कि भैया आप resolution plan नहीं file कर सकते क्योंकि the date of to check that resolution applicant is eligible or not is the date of commencement of CIRP. So matter come after NCLAT, the matter come to the Supreme Court. Supreme Court said that nahi, the date of the to check that the person resolution applicant is eligible or not is the date of submission of resolution plan. Accordingly Supreme Court ने फिर वही अपने आर्टिकल 142 ब्रह्मास्त्र को यूज किया and there he revived the timeline क्योंकि टाइमलाइन तो जा चुकी थी. So और उसने कहा कि हम आपको एक अपॉर्चुनिटी देते हैं, we are giving you one more opportunity, you can pay your dues within 2 weeks of this decision, and if you pay your dues, pay, then you can apply, you can submit your resolution plan. Next case is COC of SR Steel versus Satish Kumar Gupta. So this case is also related to the SR Steel corporate debtor. Now this in this case as well, basically this group appeal and writ petition raise important question as to the role of RP, RA, COC. RP means resolution professional, resolution applicant, COC that are constituted under the IBC, and jurisdiction of NCLT and NCLAT. So what was the issue before the Supreme Court? The role of the resolution professional, role and right of the PRA, prospective resolution applicant. What is the role of COC? What is the power of judicial review of decision of COC by the appellate authority, adjudicating authority, and the appellate tribunal? Whether the COC can constitute a subcommittee, whether the plan can provide the extinguishment of right of personal guarantor. So these are the different issues which has been decided by the Supreme Court in this case. So role of मैं इसको एक बार थोड़ा सा overlap कर रहा हूँ. Role of RP has been decided. The key role is manage the affair of the corporate debtor, appoint and convene the meeting of COC, and very important function of RP is to collect, and finally, third point, collect, and finally admit a claim of all the creditors. And Supreme Court also said that resolution professional role is not adjudicatory, it is an administrative role. Role of PRA में भी इसमें भी Supreme Court also did very detailed study. Ancestral legislative guidance and provision of CIRP regulation has been referred by the Supreme Court. Role of COC, you can also read कि commercial wisdom of COC को Supreme Court ने कहा कि वो prevail करेगी. The commercial wisdom of COC will prevail, and NCLT or the NCLAT cannot interfere in the commercial decision of the COC. जो अगर हम इस jurisdiction of NCLT and NCLAT में we will only refer the first point. There is no doubt whatsoever that the ultimate discretion of what to pay and how much to pay to each class or subclass of the creditor is with the COC. This is only the commercial wisdom of the COC that they have to take a call that how much is to pay to each class or subclass of the creditor. But the decision of COC must reflect the fact that it has taken into account maximizing the value of the asset of the corporate debtor, and the fact that it has adequately balanced the interest of all stakeholders, including operational creditor. So Supreme Court clear that the किसको कितना pay करना है, how much has to pay, to which it has to pay, is totally depend upon the COC, but they cannot decide it arbitrarily. So they have to take the interest, they have to consider the interest of all the stakeholder, and they cannot discriminate in the to the operational creditor as well. So what is the jurisdiction of NCLT and NCLAT? So Supreme Court clarified that and concluded that the AA cannot interfere on the merit with the commercial decision taken by the COC. The limited judicial review available is to see that COC has taken into account the fact that corporate debtor need to be keep going concern during the CIRP. It need the maximization of the value of asset and the interest of all stakeholder, including the operational creditor, has been taken care. And court clearly said that if the above point has not been taken care by the COC, point number 4, then it may send a resolution plan back to the COC to resubmit such resolution plan. Can the subcommittee can be constituted by the COC? Yes, Supreme Court say that the final decision will be taken by the COC, but the court however noted that subcommittee, point number 2 on the last para, subcommittee cannot be appointed for the purpose of negotiating with the resolution applicant or the purpose of performing other ministerial or administrative act, provided such act are in the ultimate analysis approved and ratified by the COC. So they said that subcommittee can be made for administrative act or the some other act, and that has to be those decisions taken by the subcommittee has to be ratified by the COC. This is also important aspect, utilization of profit of corporate debtor during CIRP to pay off creditor. So this was the one point, was like our resolution professional was operating the CD, is managing the affair of the CD, and now there is a profit in the from the operation. So can resolution professional utilize that profit to pay off the creditor? So in this case, court set aside the uncleared judgment that profit of the CD during CIRP should be utilized to pay off the creditor in the view of the fact that RFP issued in terms of Section 25 of the code and consented to be by ArcelorMittal. So Supreme Court said that that profit will be taken, cannot be utilized to pay off the creditor. Then what will happen to those profits? So Supreme Court, and we can say that what that can be taken care in the resolution plan. So in this case, Supreme Court clarified that profit cannot be utilized for to pay off the creditor. Even in this case, constitutional validity of Section 4, which is related to the minimum amount of default, and Section 6, who may initiate the CIRP, Section 6, was upheld, has upheld the constitutional validity of Section 4. Basically, these validity of these Section 4 and Section 6 was challenged in this case, and Supreme Court upheld the valid constitutional validity of Section 4 and Section 6. And also acknowledge that time taken in the legal proceeding is certainly an important factor. Next case is Swiss ribbon case. Basically, this case is versus Union of India. So now in this case, Union of India is the respondent. So what happened in this case, or what is the background of this case is, many people has filed a writ petition in the Supreme Court challenging the different aspect of the IBC. So what are the major aspects that has been challenged in those petitions? So Supreme Court merged those old writ petition and decided in this case, Swiss ribbon case. One aspect is appointment of member of NCLT and collect. So they are saying कि appointment was, there was a, उसको डिटेल में बाद में डिस्कस करेंगे what was the decision of Supreme Court. We will go through first कि what are the challenge, different aspect of IBC which has been challenged in this Supreme Court case. One is appointment of member of NCL and CLET. Second is the administration support. Third, they have challenged that there is a NCLT in Delhi only and CLET hai. Sorry, and point number 3 is and CLET is in Delhi only, not NCLT. So in this case, they changed the enclate in Delhi only. There was a argument that there is no real difference between the FC and OC, because FC has also given the money and OC has also supplied the goods or has provided the service to the corporate debtor. So they are also the equivalent to the money. And so also they made a point that this IBC has a hostile discrimination with the OC, as they are not the part of the COC, and they can be part of the COC only when the amount of 10% of aggregate of the amount of debt is the. In the one case, they have challenged that the information utility. So they are saying that private parties or the private companies can also establish the information utility. They have challenged the power of the COC as well. The power of RP has been challenged. Section 29A has also been challenged. The exemption to the MSME under Section 29 capital A is also been challenged. The Section 53, which provide the mechanism, waterfall mechanism, also been challenged. Section 3 violates the Article 14 of the Constitution of India. So these are the different challenges. Basically, this is a very good case to study, because different aspect of the IBC has been challenged in this case. So, and Supreme Court has clarified one by one. So there was a appointment of member of NCLT and NCLAT. Basically, there was a Supreme Court earlier decision of Supreme Court in case of Madras Bar Association versus Union of India. In this case, Supreme Court ordered that point number 1 में आप नीचे वाले पैरा पढ़ेंगे. In this case, Supreme Court ordered that all the tribunal member will be appointed by National Tribunal Commission, which is a central body to regulate the appointment. So on the appointment of member of NCLT and NCLAT, on the behalf of petitioner, firstly it was argued that the member of NCLT and NCLAT, apart from president, have been appointed contrary to the court judgment. And therefore, this being so, all the orders that were passed by such member being passed contrary to the judgment of Supreme Court in the aforesaid case ought to be set aside. So say that the appointment is not valid. So how if any appointment of any person is not valid, then how you can say that the decision taken by the such person is valid? So what Supreme Union of India respond? How the Union of India is responded? An affidavit is being filed by Dr. Raj Singh, Regional Director, Northern Region at MCA. This affidavit makes it clear that the government is acting in compliance with the direction of the Supreme Court. In that judgment, a selection committee was constituted to make appointment of members of the NCLT in the year 2015 itself, and the selection committee was reconstituted on 22nd of Feb 2017 to make further appointment. So that submission was accepted by the Supreme Court. Second is admission support. They said that NCLT and NCLAT are functioning under the MCA, while the tribunal the support to the administrative support has to be given by the Ministry of Law and Justice, because these like court and these tribunal are come under the Ministry of Law and Justice. But in this case, NCLT and NCLAT are functioning under the Ministry of Corporate Affairs. This again need to be corrected immediately. So the Supreme Government, the learned Attorney General has given the response. You can read that. The next case is NCLT and NCLAT is in Delhi only. So Supreme Court said that the Attorney General ensured that we are reading the CG submission. Attorney General assured that the judgment of Madras Bar Association will be followed and circuit bench will be established as soon as practicable. The court recorded this submission and directed the Union of India to set up circuit bench of NCLAT within 6 months from today. The important is there is no real difference between FC and OC. Point number 4. So the that the legislative scheme that is contained in section 7 of the code stating that there is no real difference between the FC and OC. It was stated that both type of creditor have given their either money in terms of the loan or money worth in terms of the goods or service. So they challenge the section 7 that operational creditor has, financial creditor has given the money in terms of the loan, and operational creditor has given the money in terms of goods or the service. So why there is no real difference between the FC and OC, and IBC code is clearly has a different described a difference between the FC and OC. So what was the Supreme Court view? So Supreme Court stand that view that financial creditor are from the very beginning involved with the assessing of the viability of the corporate debtor. They can and therefore do engage in restructuring of the loan as well as reorganization of the corporate debtor business when there is a financial stress, which are the things and things which operational creditor do not and cannot do. So Supreme Court says that Supreme Court has made a differentiation based on these aspects, thus preserving the corporate debtor as going concern while ensuring maximum recovery for all the creditor. Being the object of the code, financial creditor are clearly different from the operational creditor. So Supreme Court said that there is an obviously an intelligible differentiation exists between the two. This is also a good point. There is a hostile discrimination with the OC. So the point was that this OC is the not part of COC. So section 21 and 24 of the code are discriminatory and manifestly arbitrary in that OC do not have even a single vote in the COC, which has very important function to perform in the resolution process of the CD. OC can be only part of COC when the amount to 10% of the aggregate of the amount of debt owed. So what was the court observation? Court has also upheld the provision of IBC, and court observation was, since the financial creditor are in the business of money lending, banks and financial institutions are best equipped to assess viability and feasibility of the business of the CD. Even at the time of granting loans, these banks and FIs undertake a detailed market study, which include a techno-commercial economic valuation report, evaluation of business, financial projection, etc. Detailed study has already been undertaken before sanctioning a loan, and since financial creditors have trained employee, so FCs have trained employee to assess viability and feasibility, so they are in a good position to evaluate the content of a resolution plan. On the other hand, operational creditor who has provided goods and services are involved only in recovering amount that are paid for such goods or service and are typically unable to assess viability and feasibility of business. The foresaid regulation further strengthens the right of operational creditor. उन्होंने कहा कि regulation में भी even apart from this, the regulation strengthens the right of the OC by statutorily incorporating the principle of fair and equitable dealing of OC right and OC's right together with priority in payment over financial creditor. So Supreme Court ने कहा कि Supreme Court has a view that OC has given a priority in the payment also for the all the aforesaid region. The last line, the court did not find that operational creditor are discriminated against or that. So they say there is no discrimination because it is there is a discrimination, that is an intelligible difference based upon some facts. Information utility. So the provision related to establishment of IU are set up under the code was also assailed. According to the petitioner, under section 210 of the code, there can be private information utility whose sole object would to make a profit. So if you establish a private IU, private information utility, so the entity that is controlled by the private person have the only sole objective to make a profit. The said IU is not only to collect financial data, but also to check whether a default has or has not occurred. certification of such agency cannot be substituted for adjudication. Thus, the certificate of an IU is in the nature of preliminary. So what is the court observation? So court did not consider that point and upheld the establishment of IU. Said the court said that there is a strength requirement, there is a stringent process है जिसमें कि registration of IU default होता है, तो then there is a communication to all parties, surety of debt, and there is a process of authentication of and verification of information, which will include authentication and verification from the debtor as well. This being the case, coupled with the fact that such evidence which has been produced by the IU, as had been constituted by the learned Attorney General, is only a prima facie evidence. So court said that even there are stringent process, and even after that, any evidence has been produced by the IU is only a prima facie evidence of the default, which is rebuttable by the corporate debtor. Make it clear that challenge based on this ground might also fail. So court said that there is a established process, stringent requirement as there regarding the registration and for other aspect as well. And any certificate produced by the IU, even it is a private IU, is only a prima facie evidence which can be challenged by the corporate debtor as well. Power of the COC, basically section 12A है जिसमें there is a requirement की to withdraw a application there is at least 90% of the voting share of the COC is required. So they have challenged in the case that power. So Supreme Court upheld that as well. Power of RP has also been challenged. So it is important. So it was argued that RP have given the power of adjudication under the code and regulation. Grant of adjudicatory power to a non-judicial authority is violating the basic aspect of dispensation of justice and access to the justice. So they are saying RP or resolution profession is a non-judicial authority and he has the adjudicatory power. So Supreme Court, what was the Supreme Court observation is, it is clear from the reading of the code as well as the regulation that the RP has no adjudicatory power. Section 18 of the code lay down the duties of an IRP or RP. The RP given the administrative power as opposed to quasi-judicial power. In fact, even when the RP is to make a determination under regulation 35A, he is only applied to the AA for any appropriate relief based on the determination. So court made clear observation that RP is not having any adjudicatory power. He has only administrative power. So section 29A challenge किया गया. Section as far as section 29A subsection C is concerned, a blanket ban on all the participation of all the promoter of the CD without any mechanism to weed out those who are actually culprit, as against a person who was efficient manager but who had not been able to pay their debt due to various other reasons. So they made a challenge to the section 29A also as well. So the court has upheld the section 29A provision. So आप एक बार go through कर लीजिएगा. इसमें court की observation I have given in these 3 points. In the next point, where the exemption to MSME has also been challenged. So court observation was the rationale for excluding such industry from the eligibility criteria laid down in section 29 capital A is because such industry other resolution applicant may not be forthcoming, which will inevitably lead not to resolution but to liquidation. So they said that these are the small industries, and अगर हम इसमें exemption नहीं देंगे तो there may be reason, there may be cases की उन केस में resolution applicant ना आए, कोई बड़ा resolution applicant ना आए, PRA ना आए, prospective resolution applicant नहीं आएंगे, and if there is no resolution plan, then that industry can go to liquidation. So they have this is the reason that the act has given the exemption to MSME and they have uploaded the provision. Now the section, whether section 53 violate article 14, that is the article of equality, doctrine of equality of Constitution of India. So that the repayment of financial debt infused. So because the priority has given to the financial creditor in section 53. So Supreme Court view was that the repayment of financial debt infuse capital into the economy as bank and FI are able with the money and they has been paid back to further lend such money to other entrepreneur for their business. So Supreme Court said that when any corporate debtor or any company made the repayment of financial debt, it infused the capital into the economy, because the bank or the financial institute will not keep that money with them. They will again lend to such money to the other entrepreneur for their business. This rationale create an intelligible differential between the financial creditor and the operational creditor, which are unsecured. So these are the key points which we have discussed in this case. This case is also very long case, as the very important point, and also lengthy case. So I have tried my best to incorporate the key point in this presentation. Next is Swam Water Treaters Private Limited versus Union of India. In this case as well, the different part of the different section of the code has been challenged. Under the code, they said that basically in this case, first appeal was made before the High Court, under the High Court of Gujarat, and the praying for a declaration that section 5 subsection 7 6 7 section 6 7 12 29 214 231 238 under the code are ultra virus to the Constitution of India, and the appointment made of the technical member NCLAT NCLT is unconstitutional. Section 3 section 62 of the code are ultra virus to the Constitution of India. So when the matter was called for hearing in the High Court of Gujarat, a copy of order passed by Supreme Court in case of Central Administrative Tribunal versus Union of India and other was produced. High Court observed that what High Court basically made a mistake, that he took up the matter, and he said to the petitioner that the parties may approach to the Supreme Court whether this court can proceed with the matter or not. So the different part of the basically act was challenged, and High Court took up the matter, and High Court instructed the parties they can go to the Supreme Court for the decision that High Court can take a past decision on these aspects. So when the matter has been gone to the Supreme Court, then Supreme Court stand was Supreme Court observation in point number 1. The High Court is requested not to enter into the debate pertaining to the validity of the IBC or the constitutional validity of the NCLAT. So Supreme Court has clearly, we can say, directed or instructed to the High Court that this is not your domain. Why you have took up the matter and asked the petitioner to come in front of us, that you are being empowered or not. Having learned a counsel of the parties, we are only inclined to request the High Court to address the relief limited to any action taken by the respondent or any other order passed by the NCLAT. So they say that agar koi aur matter hai unki appeal mein, to you can listen or to take on the matter, but if there is any issue related to the IBC or the constitutional value of the NCLT, that you are requested not to enter into the debate. So वो फर्दर डेवलपमेंट मींस कि जो अदर इशू जो थे उन पर जो है फिर सुप्रीम कोर्ट हाई कोर्ट ने क्या डिसीजन दिया वो इसमें मैंने यहाँ पे I have mentioned there. So the only key point was that Supreme Court has requested the High Court not to enter into the debate related to the validity of the IBC and the constitutional validity of the NCLT and NCLET.
Sanjay Singhal ji, I think we can stop here and then we can take up the rest of the cases on some other day. Probably tomorrow if it is convenient to you, or on some other day.
Okay, sir.
That we can discuss separately because it's already 2 hours and I think members have had sufficient discussion on the various important issues which are
I
involved
think,
in various cases of Supreme Court.
At least 2 or 3 session is required to cover most of the cases.
Definitely, definitely.
Yeah.
Yes.
Because initial there are many initial cases those are lengthy. And
But what we can do is, actually, Sanjay Singhal ji, what we can do is, we can first start with those cases which have been introduced for the first time.
लेकिन सर अब issue ये है कि now the last time when the case was amended, the case list was amended is in March 22, and almost there is now 1 year has gone past after the amendment. So all the cases are now equal because it's all the list is 1 year old now.
Okay.
And what I have, my experience is that even these cases, which are the initial case like innovation, mobilization, are also asked in my exam still.
Definitely,
Asked in exam.
Yes, yes. So we are really thankful to see Sanjay Singhal ji, who is an IPO as well. He was kind enough to deliberate on the various issues involved in Supreme Court cases, and we'll continue further. And that intimation will be given in the group. So thank you very much. Thank you all the participants for listening to the session. Thank you very much. And this session was being recorded, and we'll share the recording with those who could not attend this session due to festivities or some other thing. Another important thing I would like to mention is that we are starting a new batch on 16th of January. So you can ask the participants who are willing to appear for the limited insolvency examination to enroll for the new batch. Thank you very much. Thank you all. Thank you, Sanjay Singhal.
Okay,
Thank you.
thank you
sir.
everyone.
बहुत अच्छा सेशन रहा था सर.
हाँ जी सर. हाँ जी. Okay, sir.